Good morning and hello. Welcome to this month's webcast, the 2017 Legal Trends for Nonprofits Update. Today's webcast is being brought to you by 501c Agencies Trust. 501c Agencies Trust is the nation's oldest unemployment program. Many of you on the call today are already working with us, and we appreciate you doing so. We've had a great year, and we're looking forward to another great year next year. We provide risk management services and related to unemployment tax benefits for nonprofits. We also have a couple other key ingredients to our product offerings, HR services, reemployment services, claims management, and a number of other insurance products. And we hope you all will enjoy today's broadcast. Good morning, everybody. How are you doing? I don't know why I do that. I always ask the panelists to mute themselves, and then I ask them how they're doing immediately after they do that. So I know they're on the call with us. We have a couple of housekeeping items before we get started. If you have any questions, you need to use the questions module of the GoToWebinar application, and we will get those handled. Those can be technical questions about the application itself, or any questions you might have for the panelists. Today's session is being recorded, and we will shoot you a copy of that recording immediately, about an hour following the session. If you look under the handout section of your GoToWebinar application, there's also a PDF of the slides for today, so you can download those. Today's session is worth 1 hour of HRCI credit. That credit will also be emailed to you an hour after the broadcast with the recording of the presentation. And we have other webcasts. We do these webcasts once a month at the end of the month. And we will hope you will come back for future webcasts. So now I'm going to go ahead and introduce our speakers. Today we have a fine lineup of minds. Jerry Panaro is counsel for Howe and Hutton in their Washington, D.C. office. He has over 35 years of experience in practice of employment law. We're representing nonprofits in Washington, D.C. and Maryland. Mike is a litigator with TLD Law. He excels in several areas of law, including litigation, intellectual property, cyber law, which is what he's going to be talking to us today, and privacy issues. Bob is a Chief Administrative Officer, in-house counsel for ASAE. He's responsible for a number of their legal departments, human resources, office services, and some conference operations, being a member of their executive team. And we're going to start with Bob this morning. Bob, welcome to the broadcast, and please take it away.
All right, thank you very much. Well, of course, for anybody who's been following the news lately on what's going on the regulatory side, the changes to the overtime rule has been taking up a lot of press, certainly within the nonprofit community, but also in the for-profit community. This is where we are, and honestly, it changes every day. And I want you all to appreciate that I don't know what the new administration is going to do with this. So a lot of where this may wind up right now is up in the air. Over the summer, the Department of Labor announced that they were changing the minimum salary threshold by a factor of 100% from roughly 23,000 to over 47,000, meaning that anybody who made less than that $47,000 figure would have to be paid overtime, regardless of what they did. Whether they could be a CEO of a nonprofit and still have to be paid overtime. And this caused a lot of consternation, of course, within the nonprofit community and with us, with our association members. We were one of the parties that did bring litigation in the Eastern District of Texas, as well as 21 states' attorney generals. And the judge there issued a preliminary injunction roughly just before Thanksgiving that has kept the rule from going into effect. Now, as part of that litigation, the Department of Justice could file for an expedited appeal, and they did, which means that it is conceivable that the Third Circuit may decide that the preliminary injunction was issued in error and the rule will go into effect immediately. However, and we think because of just they just don't have the resources to do it any quicker, the Department of Labor proposed a briefing schedule that would have the final briefs in the appeal to be heard after the inauguration. What that means is that the new administration could, if they chose to do so, decide that they weren't going to pursue the appeal and just the litigation would die there. However, late Friday night, there's a new development has occurred, and that is that the AFL-CIO has moved to intervene in the litigation. I don't know exactly what that means. It may be that if they are added as a party to the litigation, they could potentially continue the litigation adverse to the state's attorney generals and to the business coalition, even if the administration chooses not to, which could really drag out really what happens with the rule until perhaps Congress, with the new administration, decides to do something about it. In the meantime, though, I mean, I have a lot of sympathy for organizations that had to plan, they had to make changes figuring that this rule was going to be coming, and now are wondering, what exactly do they do? Some organizations, when they've made changes and announced in advance, as would be good practice, have chosen to just go ahead and keep those changes in. Others have reversed their changes pending how the rule is going to come out. Either way, it's caused a lot of issues with organizations trying to figure out the best way to do it, especially in a time of very limited budgets. Salaries are usually the single biggest budget item for nonprofits, and if the rule stays in effect or actually goes into effect, it could have a very very bad effect on a lot of nonprofits. So we'll see. I wish I had clear answers for you at that time, but right now everything is still very much in flux. And of course we'll have to wait to see what the new administration may or may not do, or what Congress may or may not be able to do once they start up again in January. And Matt, can you go ahead and move to the next slide? Some other things that have been going on, and this is taking place especially in some of the larger cities across the country. We are based in D.C., and so we're very, very familiar with what the D.C. Council is doing. The D.C. Council considers itself to be a very progressive council, and they are taking very, what many would call more liberal interpretations and passing new laws. Minimum wage increases, I think you've seen a number of cities doing that. The district is now will be increasing to $15 over the next couple of years, and already up to $11.50. And this trend has been echoed in a lot of other major cities across the country, especially those cities that are controlled by Democratic legislatures or city councils, whatever their setup happens to be. I don't see this trend going away because they feel that if they can't get it done on a national basis anymore, especially now that the Republicans have full control of both the House, the Senate, and the executive branch, that they'll just go ahead and do it on their own and dare anybody to stop them, quite honestly. So I think you're going to see this proliferating in those areas that are under the control of the Democratic Party. Similarly, paid leave is a very, very hot issue, especially maternity and paternity leave. The district council last week finally introduced a new paid leave requirement. It is more generous than anywhere else in the country. But what is most disturbing to us isn't that there's a paid leave requirement. We think overall that is a good thing to do if you can afford to do it, but that it sets up a whole new government bureaucracy to administer the leave, as well as applies a new payroll tax on employers in the District of Columbia to pay for it. That, we think, is pretty much a recipe for disaster, since it gets the district government involved in leave decisions between the organization and their employees. It could also cause loss of other benefits because you've got to figure out a way to pay this new payroll tax, which will do nothing except increase over time. The district does not have a good reputation for being able to control its costs or to properly estimate its costs. So we do see that as kind of a continuing threat to those employers that are in the district. And paid leave requirements are spreading throughout the country, again, generally in the larger metropolitan areas that are controlled by the Democratic Party. And I think this is, again, it's going to continue. It may be that we get some kind of national legislation. Certainly President-elect Trump has mentioned that he would be in favor of doing something with paid maternity at the very least. So we'll need to see, but it's unlikely that anything done on the national basis would exempt out or would preempt what the states and local jurisdictions are doing in this area. And I think you'll see this in other areas too. And another very popular one has, of course, been ban the box, meaning that you really can't ask about somebody's prior criminal convictions until the offer stage. Another has been to ban credit checks, like again, unless it's absolutely necessary for the position. And there are others. Another big one has been the wage theft laws, where payroll mistakes are essentially considered the theft of wages, and there's very much increased penalties if you don't do it exactly right and provide all the proper notices that those particular regulations require. So there's a lot of potential traps for the unwary in what a lot of the different jurisdictions are doing. This, of course, is very hard for any organization that has more than one office in more than one jurisdiction, since you've got to track what's going on in each of those jurisdictions, which means you may have to have different policies and different benefits, actually, depending on where, excuse me, your particular offices are located. I would also point out that Portland just recently passed some legislation that would provide additional taxes on CEOs who make more than 100 times the average wage of their employees. We have seen this happen before in New York as to nonprofits, where there's a limit on compensation that the CEO could draw if they wanted to work with the excuse me, the New York government. So I see that as a potential also to continue to come through, so it's something we'll have to keep a watch on. And then on my last slide, if you would, pilots. Pilots is not a new issue. Payment in lieu of taxes. This tends to apply especially to those nonprofits that have real estate holdings. They may, their office building or their headquarters they may own, but they don't necessarily pay property taxes because they're exempt as a nonprofit organization. However, the jurisdictions still have to provide services such as fire, police, rescue, and utilities, etc., to the property, but they don't get any taxes to help cover those costs. So they've been pressuring nonprofits to make these payments in lieu of property taxes. I don't see the financial restraints on jurisdictions easing up anytime soon. Every jurisdiction I know of is having financial problems. Nobody's really swimming in a lot of money. And with less money likely coming from the federal government, as the Republicans have said that they are going to be cutting back the government, that means jurisdictions are going to be looking for more money elsewhere. And nonprofits are a target. We have property. We have also reserves that aren't currently taxed. And I think with tax reform coming down, all of that is potentially in play as we go along with this new administration. It's a time to really watch for it and be vigilant, and make sure you're keeping an eye on what's going on. And when coalitions pop up that can serve your interests, please consider joining them to help get and help protect the nonprofit organizations. And with that, Mac, I'll go ahead and turn it over back to you.
All right, thank you, sir. Mike, it's your turn, sir.
Okay, good morning or good afternoon, everyone. My name is Mike Hellbusch. I'm an attorney out here in California, so it's morning for me. I was going to talk a little bit about maybe the top five important trends I see with regard to cyber policy and privacy policy. So the first one I think that probably has the most question about it is increase in regulations. We can see that this trend's been going on for a while. More and more governmental entities, both on the federal and the state level, have been increasing the regulation and the attention being paid to cyber and privacy policies. A good example of that is under the Dodd-Frank Act, passed right after the financial crisis in 2008, there was the creation of the Consumer Financial Protection Bureau. What that was intended to do was to create an enforcement arm that would go after unfair, deceptive, or abusive acts or practices in connection with consumer financial products. Really, one of the major contributing factors to the financial crisis. Recently, the CFPB has just completed its first enforcement action, and it went after a company that didn't protect or didn't have the adequate notices with regard to data protection and privacy policies. Important for that was that the consent decree that the parties entered into, there wasn't any allegation of data breach or data leaks. This was just a intervening factor that the CFPB said we want to correct this before there is a problem. So you can see that there's more of an increase in regulations. The flip side to that is that Trump has said he wants to dismantle Dodd-Frank, so that could include the CFPB. So it's really unclear what is going to happen in that regard. But I don't think the trend's going to reverse at all. We can see it on the state level that even state governments are increasing their enforcement efforts with regard to privacy and cybersecurity issues. A good example of that is out here in California. The state attorney general Kamala Harris, who's now a senator-elect, just released the announcement of an online tool that will basically allow the crowdsourcing of privacy violations. And what the tool does is it allows any sort of consumer, any person in the general public, to point out violations of the California Online Privacy Protection Act. So you can go to a website, and if they're not compliant, you can report that to the Attorney General, and the Attorney General will take it from there. This is a big step. I think it's the first of its kind in terms of crowdsourcing privacy violations, and really the goal is to make sure that all websites and all companies that have personally identifiable information about their consumers are taking the adequate steps to not only protect that information, but also to be transparent and inform the public of what their privacy and cybersecurity practices are. If you're not familiar with the California Online Privacy Protection Act, it basically says that a website or app operator will violate that law if they fail to post privacy policies or post incomplete or inadequate policies. What happens is if they collect personally identifiable information of a California consumer, such as the name, address, email address, phone number, social security number, etc., then they have to post this privacy policy in order to comply with the law. It has to include certain categories of information collected, like the types of the third parties with whom the operator shares that information, instructions regarding how a consumer can review or request changes to his information, and the effective date of those privacy policies. So when these privacy policies took effect, and whether or not there's going to be any retroactive effect for any changes. So you can see that there's going to be this ongoing trend of asking the general public to help enforce privacy issues. I think that's something that all nonprofits should be aware of if they collect personally identifiable information. And then second, on the healthcare side, the Office of Civil Rights, which is the enforcement arm for HIPAA violations, has indicated that they're going to be conducting more on-site audits of hospitals in 2017. So that just means that people have really got to be stepping up their game in terms of ensuring HIPAA compliance, making sure that all their data is protected, the privacy rules, the security rules are in compliance. So that brings us to number 2 topic, which I think is insurance sophistication. For the last few years, insurance companies haven't really had a great grasp on what there's going to be coverage for, what they can't cover in terms of privacy or cybersecurity violations. We're seeing that change. Insurers are becoming increasingly sophisticated with respect to cyber liability issues. And so for nonprofits, there's definitely an onus that they should be aware of the risks with respect to insurance coverage and appropriately mitigate those risks. We see more and more insurers carving out exclusions or specific policies based on the type of injury that occurs. So, focus should be on first-party coverage with loss of income, regulatory defense or penalty coverage, coverage for ransomware or cyber extortion, the transmission of viruses, failure to disclose a privacy incident can be an excludable event, avoidance of minimum security standards, and exclusions based on what the particular definition of personally identifiable information is. So, as the new year approaches, it's a good idea to review the policies that are in place. If there's a particular concern within your organization, you should check what the language says, maybe talk to a lawyer about what the policies say, what the exclusions may be, and determine whether or not you need to supplement with your risk management portfolio. Number 3 is privacy by default. Privacy by default is this idea that companies that deal with consumer information, private information, should err on the side of protecting that information. And it's something that's kind of a mantra for privacy experts. When you're dealing with a cybersecurity portfolio, you want to err on the side of privacy. And that's because companies are increasingly confronted with the privacy issues. We talked about the CalAPA online tool. It's going to be the de facto standard for designing a business online with an online presence. What that means is there should be specific attention to data mapping, figuring out how your information is collected, where it's stored, who gets to see it, all of those things. The webinar I did last month talked a lot about those issues. And so the incorporation of privacy by compliance is going to be done by the way of consultants, specialized employees, or even legal counsel, and insurance, like I mentioned before. And I think what we talked about before, the increased regulations and the sophistication, there's going to be more attention paid to those companies who don't abide by privacy by design. Number 4 is the increase in ransomware. I just read an article that talked about ransomware is becoming more and more prevalent because it's easy to do for online hackers, for online extortionists. What a ransomware does is basically it sends a packet of information into a computer that encrypts all of the information on that computer. And the way that a person has to basically breaks that encryption is to pay money to the cyber extortionist, usually in the form of Bitcoin, and they sometimes unlock that information, sometimes don't. But generally, it's a difficult issue. Law enforcement says don't pay those ransoms, but a lot of companies do just because they need to get their information back. We've seen extortion demands in these types of ransomware demands anywhere from about $5,000 to $10,000 generally. The article I read said that could be increasing almost even tenfold or more because people, the cyber pirates, are understanding how effective that is and how valuable that information is to a company. Being down for a certain amount of time is really, really expensive, and so cyber pirates are really understanding that this is an effective tool for them. And then there's the additional costs for unencryption, for personal, for PR, for the time lost, for experts in order to facilitate and really mitigate the risks. And then, there's a consequential increase in the phishing and the user manipulation efforts to prevent these types of attacks. Really, the way that these attacks occur are through employee error, basically clicking on the wrong email, downloading something they shouldn't download, and the costs are going to increase from there in order to train those employees. And that kind of brings us to the final point, is that there's more and more attention paid to small businesses and mid-sized businesses from both the bad actors and also to the government. Larger companies are really leading the way in employing stronger security and tighter controls, but breach incidents are going to trickle down to the small and mid-sized companies, which are, more often lax on cybersecurity, more often don't understand how their cybersecurity is run, what it does, where their information is held, and generally don't understand or even know whether a breach has occurred. Human error is generally the leading cause of intrusions. That means employee training is going to play an important role in security strategy. Some studies estimate that 50 to 80% of companies that have experienced a breach are small to mid-sized companies. Yet those same organizations have been very slow to adopt meaningful framework and policies. So overall, what I've discussed here is that there's going to be a lot of attention paid in the coming year and in the coming years to cybersecurity for small and mid-sized businesses, and that's not exclusive to for-profit companies. Any businesses that handle personally identifiable information of consumers are going to have the spotlight shown on them. The best thing you can do is to have a self-spotlight and really address the issues upcoming, so that you don't get caught in a regulatory action, you don't get caught in a attorney general action, and hopefully you don't get caught in some sort of piracy or bad actor incident where you have a data breach or you have a ransomware attack, anything like that. So with that said, I'll pass it back to Mac, and thank you for having me.
Absolutely, sir. Thank you so much for all those 5 points. Jerry, you're up, sir.
Okay, thank you very much. I'm briefly going to address four issues. New guidance from the Department of Justice and Federal Trade Commission on anti-poaching, EEOC, NLRB, and the Occupational Safety and Health Administration. So if we can go to the next slide, Mac. Back in October of this year, just a couple of weeks ago, the Federal Trade Commission and the Department of Justice issued antitrust guidelines, which basically make what are called anti-poaching agreements illegal. In other words, any agreement between competitors not to hire one another's employees or to exchange salary, wage data, etc., with the idea of fixing wages or something of that sort, the FTC and Department of Justice say is per se illegal, which means there are no defenses, no excuses. If you engage in it, you're guilty. And that includes exchanges that are facilitated by third parties. So to take a concrete example, we actually had a case like this with an association who had a policy, an anti-recruitment policy that basically said to all its members, when you go to our meetings or conventions or seminars, et cetera, you are not to attempt to hire one another's employees. You are not to attempt to recruit one another's employees. This is unprofessional, et cetera, et cetera. And one organization did, in fact, recruit some employees from another. The other organization complained, came to the association and said, we want you to enforce the policy, otherwise we may not renew our membership. And based on this guidance from the Department of Justice, my advice was, under no circumstances can we do that. We certainly don't want to lose a member, but on the other hand, we certainly cannot go to one member and say, don't recruit the employees of another. So that guidance came down, as I say, in October 2016. And also, you should avoid sharing sensitive information with competitors about terms and conditions of employment as well. So those 2 points. No poaching agreements are, as I say, per se illegal, automatically illegal, no defenses, and avoid sharing sensitive information. As one example, the Department of Justice sued the Utah Society for Healthcare Human Resources Administration at Utah hospitals on the grounds of conspiring to exchange non-public, prospective, and current wage information concerning registered nurses. So, Mag, if we go to the next slide, I think it's slide 15. For about the past 20 years now, the EEOC has vehemently opposed mandatory arbitration agreements. And basically what these are either policies in a personnel manual or freestanding policies or clauses as an employment contract which says that any and all disputes, including allegations of unlawful discrimination, harassment, retaliation, etc., are to be resolved through binding arbitration and not file a claim in court. This is a very contentious issue because the courts have been very strong, virtually unanimous in upholding arbitration agreements, saying they are perfectly legal, perfectly enforceable, in line with federal policy. So if you did want to have a mandatory arbitration agreement, more likely than not, if it were challenged in court, it would be enforced. But at the same time, as I say, this has been the position of the EEOC for the past 20 years, and it's not giving up on it. The EEOC adamantly opposes mandatory arbitration agreements and on occasion has gone to court. Perhaps the main thing to realize about, and this is in the context of settlement or severance agreements. You know, you fire somebody, the person comes back and complains that the person's being terminated because of illegal discrimination, harassment, retaliation, etc., etc. You negotiate, you get a settlement agreement, and you sign a release clause. Keep in mind that you cannot prevent, even with the separation agreement, even with the release clause and a waiver and a covenant not to sue, etc., you cannot prevent a person from filing a charge with the EEOC or from participating in an investigation, either under federal law or under comparable state law. So that is one limitation with severance agreements or release clauses. You cannot prevent the person from filing a charge or participating in an investigation, nor can you prevent the EEOC or a comparable or equivalent state enforcement agency from initiating its own investigations or even litigation. Okay, so that's one limitation on settlement agreements. Now, the EEOC does support voluntary arbitration. If the agreement is truly voluntary and the parties enter into it mutual agreement, that's fine and dandy. But in terms of imposing arbitration on a party, the EEOC takes the position that this undermines the effectiveness of all these federal anti-discrimination laws, and therefore, in certain cases, the EEOC may elect to challenge a mandatory arbitration agreement. But as I said before, courts have been pretty uniform in enforcing mandatory arbitration agreements and taking them out of the court system. So, Mike, if we can go to the next slide, I want to talk a little bit about the National Labor Relations Board. The NLRB enforces the NLRA, National Labor Relations Act. And as Bob was saying before about the overtime rule, this may change. This whole enforcement strategy may change with the change in administrations. But over the past year or two, the NLRB has been very active in filing unfair labor practice charges against private sector employers and even nonprofits for certain practices or activities. Two of the areas that in particular have been the subject of NLRB complaints have been policies in personnel manuals which forbid or prohibit employees from discussing with one another their salaries or wages or compensation plans. Sometimes a personnel manual will say, for example, what we pay you is strictly confidential between us and yourself, and you are not to share your salary information with anybody else. You're not to disclose any information to anybody else, etc. The NLRB takes the position that policies like that violate the National Labor Relations Act. Another big area is in this whole social media context. Perhaps it's less common now, but at least in the past, before the NLRB got active in it, organizations might have policies which said that you cannot defame anybody, you can't say anything bad about the company, you can't give any information, you can't put any complaints on social media, etc. And again, the NLRB takes the position that such policies violate the National Labor Relations Act, which guarantees workers the right to engage in quote-unquote protected concerted activity concerning the terms and conditions of their employment. So if you fire an employee or discipline an employee or take any adverse action against an employee as a result of what he or she posts on a social media, that could violate the National Labor Relations Act. And some people are under the impression that that they don't have to worry about the National Labor Relations Act if they don't have a union. And of course most nonprofits, their employees are not represented by labor organizations. But that is not the case. The National Labor Relations Act, with certain exceptions, which we don't have the time to go into today, the National Labor Relations Act applies to all employers, whether their employees are represented by labor unions or not. And it also applies to nonprofits, for-profits or nonprofits. So just because the fact that somebody's a nonprofit does not mean it's automatically exempt from the National Labor Relations Act. So that's an important point to realize. And as I said before, the National Labor Relations Act gives employees the right to act together to try and improve their pay and working conditions with or without a union. So if an employee is fired, suspended, penalized, disciplined, etc., he or she can file a charge with the NLRB. And example of some recent cases, a supervisor at a dental association, again, nonprofit, was fired after she refused to divulge the names of employees who had signed a petition against top management. Filed a charge with the NLRB. The board found that the discharge was unlawful because she refused to violate federal labor law, or because she was punished for engaging in concerted activity. And there was a settlement of that complaint. And in that settlement, the supervisor and another former employee waived reinstatement. They didn't want to go back to work, but they got a $900,000 settlement for lost wages and benefits in lieu of reinstatement. So that incident cost that organization close to $1 million with the NLRB charge. Another example was a construction contractor who fired 5 employees. These are all immigrants from El Salvador, after they appeared in a YouTube video complaining about hazardous working conditions. And again, that case was settled, and the workers received full back pay, but they declined reinstatement. So this is another area to be aware of with the National Labor Relations Board. Mac, if we go to the next slide, I just want to mention on OSHA.
Jerry, let me stop you right there.
Go ahead.
Let me stop you right there. One quick question about the NLRB.
Yeah.
When they're conducting an investigation, is the employer allowed to ask employees not to discuss working conditions and whatnot during the investigation? What kind of instructions? What kind of
that's a good question, Mac. If you are a supervisory employee, you, the employer, have the right to sit in on any interview of that supervisory employee with the representative of the NLRB, whether it's somebody from the General Counsel's office, investigator, or whatever. But other than that, the employer cannot instruct its employees not to cooperate with the NLRB, not to talk to them, not to be interviewed. That's just another separate violation in and of itself. So no, you can't do that. Okay.
Gotcha. Thank you, sir.
All right. Now, with respect to OSHA, a couple of things here. Of course, the statute, the general duty statute, workers have a right to a safe workplace, so the employers have to provide the employees with a safe workplace. You can't retaliate against employees for filing a charge or a complaint. And one thing in particular I want to talk about, especially in light of all these terrorist attacks, is that the OSHA does have a directive on enforcement procedures for investigating or inspecting incidents of workplace violence. The definition of the workplace violence, as the slide there says, any act or threat of physical violence, harassment, intimidation, etc. Examples include threatening behavior, verbal or written threats, harassment, physical attacks. 2 things I want to mention about this. Number one, an anti-bullying policy or a workplace violence policy is separate from and actually broader than an anti-harassment policy. Under Title VII, which forbids discrimination on the basis of harassment, gender, etc., you have an anti-harassment policy. Under a workplace violence policy, you would have an anti-violence policy, anti-bullying policy, which is even broader. Second point is this: if you take that San Bernardino case where those people were murdered and wounded, that is actually covered by workers' comp. So those employees who were wounded and have gone through horrendous medical problems, etc., they can't sue the employer. They have to do that through workers' compensation. Now, in some cases, if a criminal act is considered to be a supervening event, that may not apply. But a workplace violence situation is likely to be covered by workers' compensation. So that's another point to keep in mind with the workplace violence. So with that, I'll stop. I think I went a little bit over time. My apologies, and turn it over for questions.
No, you did great. Thank you so much, gentlemen. So we do have a couple of questions that have come in through the queue and through chat. I'm going to stay with Jerry since he was speaking last. Jerry, we have some questions in the queue about the antitrust poaching rule. Can you clarify that in a different manner? We have some folks on the call still kind of fuzzy on what you were talking about.
All right. Well, where this arose, I think, was the case that you had either last year or the year before, where some of the companies in Silicon Valley, Apple, Intel, Google, Microsoft. In fact, I think this may have started, if I have this correct, Steve Jobs of Apple called up his other fellow CEOs, called up Bill Gates, called up people at Hewlett-Packard, etc., and said, look, stop poaching our employees. Stop hiring my employees away. And I will stop hiring you. And let's all of us agree that we will not hire one another's employees. We will not poach. We will not raid. So Intel's not going to come into Apple and try to take away our engineers. Apple's is not going to infiltrate Microsoft and try and take away Microsoft programmers, etc. Let's have an agreement that all our employees are off limits to one another. And the Justice Department brought a lawsuit, and if I'm not mistaken, the settlement, these things mostly end up getting settlement, close to $500 million. I think it was a $400 million settlement. The Justice Department took the position that that was in violation of the antitrust laws, which prohibits conspiracies and restraint of trade. So the Justice Department came out with this guidance, and the popular title of it is so-called anti-poaching, and said any agreement whereby one company agrees with another not to hire each other's employees, or through a third party, like an association, says let's have a policy that at our association meetings we will not recruit one another's employees, we won't offer one another's employees jobs, etc., etc. That is what's called a per se violation of the Sherman Act. It's always everywhere illegal. It doesn't matter what the reason is. It doesn't matter what the justification excuse is. It doesn't matter if it lowers costs or anything else. It's per se illegal. So that's basically what that policy is, and it applies to nonprofits because, of course, they are the medium, or they are the media through which competitors get together and have discussions with one another and can come to agreement. So it applies to associations as well as to the individual member companies. I hope that clarifies it.
Okay, thank you, sir. Bob, I have also somebody wanted you to clarify a little bit better the pilots. Is there any way that you could broach that subject one more time and maybe try to discuss the basics of it a little bit?
Sure, and what it really comes down to is the local jurisdiction that collects property taxes is hurting for money. So they may not want to raise taxes, they may not be able to raise taxes. So they're looking at the people that don't pay taxes. So that, of course, hits the nonprofits that have property, like their headquarters building, that they're not paying property taxes on because they're exempt as a nonprofit organization. And they basically, this has happened in D.C. a lot with the universities. We have several very large universities that take up a lot of real estate within the district but don't pay real estate taxes. So instead, the administrations start pressuring them to make these other payments. They're so-called voluntary payments. Personally, a voluntary payment with the threat of having to pay it anyway isn't particularly voluntary, but it's a way of trying to stave off the potential loss of the tax exemption for the property taxes. Similarly, there's been, especially with Senate Finance Committee with Chuck Schumer, who's going to be the Democratic minority leader with the new administration. He has looked very carefully into the reserve policies of both universities and other nonprofits, especially AARP, and saying you've got too much money, you're not paying taxes on your investment income. There's going to be, I guarantee you he's going to be trying to get legislation in that is going to be able to tax some of those holdings. So pilots are a part of the problem, these voluntary payments in lieu of taxes, but it's endemic of a much larger issue, which is legislatures, both at the federal and local levels, are going to be looking for more money, and they're going to go where the money is. And unfortunately, that is often us.
I understand. Thank you for clarifying that a bit further. Mike, I do have one inquiry for you about the cyber privacy practices that you had mentioned during your section. Is there a resource that our attendees can go to, perhaps a website, to find, perhaps a checklist or a template as to what they need to make sure they're covering? I think. Can we hear you now, Mike?
There we go. Can you hear me?
I gotcha. Go ahead.
Okay. Yeah, that's a good question. Yes, most of the enforcement agencies that enforce the regulatory standards usually have some sort of guidance on their own website, and actually the California Attorney General's website is a very good place to start. In most respects, California has the most prescriptive cybersecurity laws in the country, and so with regard to privacy policies, there's definitely a lot of information about what needs to be in those, how to craft them, how they're enforced, things like that. And so if you're in a particular state, you can go to your own state's Attorney General website and look for that particular information. But one thing to note is that if you're collecting information about residents of other states, generally that resident state's laws will apply to that resident. For example, California collects, CalOPA provides or applies to any companies that collect information about residents of the state of California, regardless of what state that company is in. So that's a good place to start. And then if there's any sort of sector-specific locations that the company is in, they can go there for example, the FTC or the Consumer Financial Protection Bureau. Any sort of financial enforcement agency is going to have some sort of information online with respect to privacy policies.
Excellent. Thank you so much for telling us where we can go to get those resources. Just to remind everybody that we will be shooting you a copy of copy of the presentation by email about 2 o'clock Eastern today, and you can get a copy of the slides in the handout section of the GoToWebinar application in front of you. Jerry, I'm going to come back to you, and I'd like the other Bob and Mike to add in if you can. But you've stirred up a hornet's nest with the whole anti-poaching discussion point of getting a couple of questions in there, such as, would it be a violation if nonprofits agree to hold salaries at a certain level for certain positions? Would that be some kind of anti-poaching issue?
Mac, any agreement between competitors, is going to be an antitrust violation. So if you have, and maybe Bob can comment on this, but if you have ABC Association, and ABC unilaterally sets its own wages and compensation plans, even if it does salary surveys or takes surveys or surveys the market, et cetera, et cetera. If ABC Association unilaterally sets its compensation policies, that's fine and dandy, perfectly legal and legitimate. However, if ABC Association goes to XYZ Association, or ABC Association goes to its own chapters and affiliates and says, or let's say, let's say through ASAE, which is the Association for Associations, all right, says, okay, look, let's all agree Let's all agree that we're not going to pay a meetings planner more than $100,000 a year. Well, let's all agree that we're not going to pay an IT person more than $85,000 a year. That violates the Sherman Antitrust Act. That is agreement that is what's called per se. It's automatically illegal, no questions asked.
Yeah, and I have to echo what Jerry says. Yes, you cannot get together with other organizations or other people and say, we're going to limit what somebody can make. That is with the new guidance. And I don't even really think that it's new guidance. They're just making it clear that this always was going to be an issue because you're restraining competition for salaries. It may be for all the good reasons, maybe to help the nonprofits survive or whatever the case may be, but you simply cannot do it without being in violation of the Sherman Antitrust Act. Another place these types of issues pop up often are in ethics or standards of conduct policies that a lot of associations have for their members. And it's not only with stealing employees, but it's also potentially with poaching other customers. A lot of small associations especially have been hit by the FTC with enforcement actions because their standards of conduct for members say that you can't take customers from another member. And they have straight out said that you cannot make that kind of restriction, and it's cost these very small associations a lot of money because they simply don't have the resources to even fight it to begin with. So not only do you need to be careful on the employment side and that you're not agreeing to poach employees, but you have to be careful with any standards of conduct that you pass for your members to make sure they comply.
And Mac, if I can add one other thing, when Mike was talking before about the California website where you go to the website so you can file complaints, etc. The DOJ and FTC in their guidance have the exact same thing. If you look at that guidance, they have a phone number in there where they encourage people to call if there's any suspicion whatsoever that this is going on. I don't know if I forget if it's an 800 or toll-free number or something, but it's analogous to what Mike was saying about California. There's a phone number in the guidance that encourages people to call, to register. Register complaints, but to talk about situations of these type of agreements. So yeah, it's something it's something to be aware of. And Bob's right. It's nothing new. I mean, this stuff goes back for years and years. But the guidance is that to be so explicit in writing, case studies, examples, etc. Yeah, that just came out in October.
Okay, and what about Jerry? What about funders? Can funders have things in their grant agreements that say that the nonprofit couldn't hire anybody from the Funders Association, or is that outside?
Yeah, that's a non-compete agreement.
Okay.
And that's a whole separate thing. And a lot of states have statutes regulating non-compete agreements. I think, for example, Mike might comment on this. California, I think, forbids them, except in very limited circumstances, like if you're selling your business. And basically, a non-compete agreement is legal and enforceable. It's got to be reasonable. It can't deprive the person of a right to make a living. It's got to be geographically limited to where the company's doing business, and it's got to have a temporal limitation on it. 6 months, 1 year, 2 years. I wouldn't go much beyond that. That's a little bit different. But yes, a non-compete agreement's generally legal and enforceable.
And this is Bob. The other place you often see it is with vendor agreements, but I could also see it in the donor context too, where you agree not to steal employees from each other during the term of the contract and for a year afterwards, because you've gotten to know the people that you're working with, they're providing services to you, and you want to try to take them from the vendor or vice versa. And I don't think that's going to be an issue under the antitrust laws. Again, provided you, as Jerry talked about it's limited to a very small group of people and limited in time. It can't be a forever kind of issue.
And Mac, if I can add, there's one thing to consider. The thing to consider is this. rather than have it, because non-compete agreements can be tough to enforce if somebody actually challenges them. One thing to consider is this: instead of having a pure, simple non-compete agreement that just says you won't hire our employees, put a clause in there that says if you do hire one of our employees, you have to compensate us. So if you want to hire Jerry Panaro away from us, that's fine and dandy. But if you do that, you have to pay us, $500,000. His salary for a year, our costs of replacing him, training, loss, et cetera, et cetera. That in itself will be a deterrent, but that might be another way of dealing with a situation like that. You don't just have a blanket prohibition, but you say, A, you can't hire our employees, but B, if you do, you have to compensate us.
Excellent.
That's something to consider.
Thank you. And we all know that Jerry's worth far more than $500,000.
Oh, yeah, got it. 100 times as much, right, Bob?
Yeah, there you go.
Exactly. All right, well, that'll wrap it up for today's webcast and for this year. For Mike, Jerry, and Bob, we'd like to thank you all for attending. You can see on your screen we have another one at the end of next month. We hope you will enjoy us, attend at that time as well. Thank you, gentlemen, so much for your help, and everybody have a safe and happy holiday season. Bye-bye.
Thanks, Vic. You
Thank
too.
you very much.
Take care. Bye.